Sure. This is the state of Wisconsin versus Zachary Midstock, 26 CF 1129. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio. Good afternoon.
Mr. Midstock appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Midstock is eligible for public defender services. Now, we have received a copy of the criminal complaint. At this time, we'll waive its formal reading. I think the best address at this time would be the Dane County Jail.
Right, and it looks like that's because there's a DOC hold. You have the right to have an attorney represent you in a case like this, sir. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible. Find probable cause in the complaint. What are the state's recommendations?
I'm recommending a $1,000 cash bail in this case. For conditions, I'm asking that the defendant have no contact with Officer Eric McCarthy or Officer Jeremy Reutabuch. Their last name is spelled Reutebebuch.
That's not true.
And no contact with Michael Schmidtkofer. Their last name is spelled Schmidkofer, except in their official capacities as law enforcement officers. Here, Mr. Midstocky was out on an active PO warrant. There was also active probable cause out for his arrest at the same time, and law enforcement were called after an alert to a disturbance that was occurring. Law enforcement arrives, they see Mr. Midstocky, they notice that he has an active warrant, and so they conduct an arrest. And in the midst of doing that, Mr. Midstocky resists law enforcement, elbows to the cops, causing them pain, without consent. A third law enforcement officer scrapes his knee in the attempt to apprehend Mr. Midstocky. Mr. Midstocky, as the court alluded to, was on probation when this offense occurred, which is a bail consideration. And then I'll also note that Mr. Midstocky has had bench warrants issued in the past on July 11th, 2023 and August 4th, 2022. Given the resistive obstructive conduct, the fact that this was done while on supervision, and the fact that there are prior bench warrants issued, I think some cash is appropriate.
All right, and I just want to double check the complaint because one of the officers had an injury to their hand. I believe other officer had an injury, but it wasn't from scraping his knee. I did see that, but I didn't believe that that was the basis for one of the batteries. So just want to double check.
Right. So I think that one was actually referred up as a cause soft tissue injury. We declined that one. The charges stem from the remaining two officers involved in the case.
Okay, that's what I thought. Attorney Wyndham.
Yeah, we'll be seeking a signature bond here in this case for a number of reasons. I would note that Mr. Midstock is a lifelong resident here in Dane County. He does have two children that reside within the community with him, as well as a spouse and extended family and friends. He is eligible for public defender services, showing his indigency. And so for those reasons, I do believe that a signature bond would be appropriate. I note that Mr. Midstock is currently on a PO hold. I do believe that probation and parole is closer to the situation. I do believe that any amount of cash bail would essentially hold him and bar him from getting into any kind of treatment or alternatives to revocation. And so for those reasons, I do believe that a signature bond, with the understanding that giving probation and parole the opportunity to potentially give him an alternative to revocation would be appropriate at this time, given the nature of the conduct here and the circumstances surrounding this case. Thank you.
Any response from the state?
No.
Okay. I certainly understand your position, Attorney Wyndham, and it makes sense. However, things can happen with the revocation process where it doesn't necessarily lead to treatment, lead to no consequences or very little consequences. there is a PO hold, so in some sense, this is an academic exercise. I'll order $1,000 cash, conditions that you have no contact with officers Eric McCarthy, Rudabutch, and Schmidt-Cocker, as spelled by the state, except in their professional capacities as police officers. I'll enter a not guilty plea to count 3. Counts 1 and 2 are felonies. Will the time limits be kept?
We'd ask for a timely prelim.
Okay. We'll keep the time limits in place then,
And then there's a resistant.
and we are adjourned. Thank you.
Next will be Gabriel Rodriguez, attorney. He is willing to be there are technical difficulties. We'll have to move on to Timothy Harold. Timothy Harold.
This is the state of Wisconsin versus Timothy Harold, 26 CF 1127. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Timothy Harold appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Your Honor, at this time, we are unaware if Mr. Harold is eligible for public defender services. I have handed him a copy of the public defender sheet. At this time, we acknowledge receipt of the criminal complaint. We'll waive its formal reading. We'll stand in mute to any misdemeanor charges, though I believe they're all felonies.
All right. So you may be eligible to have the public defender represent you. You said you were unaware if he was eligible, correct?
We're unaware. He has been found eligible in previous cases. However, he needs to apply on this case. I've handed him a copy of the sheet to apply. I would note that I have previously represented Mr. Harold. There was a conflict with my office, so I had to withdraw. But for the purposes of the bail bond here today, we should be perfectly okay.
So you have the right to have an attorney represent you in a case like this. You may be eligible for the public defender. You'll just need to complete that application process, okay? I find probable cause in the complaint. What are the state's recommendations?
I'm requesting a $4,000 cash bail in this case. For conditions, I'm asking that the defendant be banned from the 3300 block of Packers Avenue and that the defendant be banned from the Granite Ridge Apartments. It looks like Mr. Harold was ordered to post $4,000 in 26 CF 908 for a similar Act 3 eligible burglary offense. In this case, Mr. Harold was out on bond in 2 felony matters with similar charges. He was on a signature bond in 25 CF 2344 and posted $250 cash in 25 CF 2586 on November 26, 2025. He missed court in both cases in March of 2026. And he had bench warrants out for his arrest in those 2 matters when he committed the offense here. Furthermore, he has older failures to appear ranging from 2018 to 2021. So I think significant cash is necessary.
All right.
And I guess I'll also point out burglary is an Act 3 eligible offense. So that certainly matters here too.
All right. I'll note. All right, Attorney Wyndham.
Yeah, I would just like to turn your attention to 25 CF 2586. That is a burglary count in here in branch 8, where Mr. Harold was previously out of custody and then was brought back into custody in regards to a warrant on a missed court appearance. Upon going back in front of the judge, cash bail was set on April 24th of 2026 in the amount of $500. So that would have been 11 days after this incident happened. Mr. Harold has been in custody the entirety of that time since that incident. Since that cash bail was since that cash bail was imposed. That $500 is remaining to hold him in regards to the circumstances. I do believe that this is a case of similar exposure and similar kind of content. And I do believe that a bail in the amount similar to that would be appropriate. So I do believe that $4,000 is excessive here. So I do believe that something in the amount of $500 to $750 would be appropriate, given what Judge Hilton set on April 24th of this year. Thank you.
Any response from the state?
One second, sorry. No, thank you.
Yeah. Well, we're in Act 3 territory, and I think in Act 3 analysis mandates higher cash. It may be that he has another case that's similar. However, multiple cases, I think, exponentially increases the exposure as opposed to just linearly increasing that exposure. Just because if somebody's committing lots of crimes, it's upon conviction, a higher chance of jail being imposed here. Mr. Harold has past convictions. He's currently on felony bail for 2 cases. He picks up another case with similar behavior alleged. It's just, cash is just necessary here. It's also possible that bail in other cases gets modified or changed. I think anybody taking a look at it in its totality should have each case reflect the unique nature of each case. I'm going to order $4,000 cash. And it was at the 300 block of Packers Avenue.
It was the 3300 block.
Okay. A band from the 3300 block of Packers Avenue and a band from Granite Ridge Apartments. These are felonies.
Yes, I would ask for a timely prelim.
Okay, we'll keep the time limits in place for the prelim then, and we are adjourned.
Next, Gabriel Rodriguez, Bill Sleazy has a technical issue for Rich.
Thank you. All right, we have Mr. Rodriguez. Give me a thumbs up or unmute.
Hello.
Hi, we're gonna get your case called here and get going, okay? This is the state of Wisconsin versus Gabriel Rodriguez, 26 CF 953. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Gabriel Rodriguez appears in custody and via Zoom and from Winnebago. With-
You're right back.
Okay, sorry, via Zoom at the Dane County Jail. We'd acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to counts 2 and 3 and 4. The best address for Mr. Rodriguez to receive mail is the Beacon still the best address for you to receive mail at?
It is.
And he is eligible for public defender services.
You have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're gonna work on getting somebody appointed for you as soon as possible. Find probable cause in the complaint. What are the state's recommendations?
I'm requesting a $1,000 cash bond in this case. For conditions, I'm asking that the defendant have no contact with any employee of the Dane County District Attorney's Office, except in the form of written communication. That the defendant be banned from the men's shelter. That the defendant have no contact with Devlon L. Their first name is spelled Devlon, as in Nancy. I would also ask that the defendant have no contact with Officer Cody Campbell, except in his official capacity as a law enforcement officer, and that the defendant not use or possess any dangerous weapons. It's my understanding that Mr. Rodriguez is the named victim in a substantial battery case involved in our office. In February, March, and April, he sent disturbing messages to the Dane County District Attorney's Office about killing the defendant in that case and possibly a citizen. Law enforcement is then called out to the men's shelter because there was a report of Mr. Rodriguez slapping other people in the shelter. When law enforcement arrives and attempt to place him into custody, Mr. Rodriguez threatens to stab the officer involved with a pencil. There's obstructive and resistive conduct here, which is always concerning from a bail perspective. Sorry, 1 second. I'm not aware of any missed court appearances. Or much, well, I don't think I'm even aware of any criminal history. But I think it's concerning the lengths that Mr. Rodriguez was taking in order to commit the actions involved in this case. And I think that cash is necessary as a result.
Attorney Wyndham?
Yeah, I would be seeking a signature bond, which is consistent with the public safety assessment here. I would note that Mr. Rodriguez is both a 1 out of 6 on the new criminal activity scale, as well as a 1 out of 6 on the failure to appear scale. This is due to the 0 of prior failures to appear, as well as the 0 prior convictions in relation to the circumstances. Mr. Rodriguez is eligible for public defender services. He's indigent. The address that he has provided to the court is that of the Beacon. He is currently unemployed and is a lifelong resident of Wisconsin. I think given the nature of his circumstances, both financially as well as the circumstances surrounding this case, where there was a mental health check in place in regards to the circumstances here, I think any amount of cash would essentially be holding him indefinitely. Based off of the evidence-based tool, as well as the circumstances surrounding this case, I do believe that a signature bond would be appropriate and adequate to both ensure his appearance in court, as well as adequately protect the public. And so for all those reasons, we would ask for that signature bond. As far as the non-monetary conditions here, I would just ask the state to provide the actual address of the men's shelter so that it's more specific in regards to that and refrains from any confusion in regards to which places that Mr. Rodriguez is not allowed to be at.
Right, and specifically which men's shelter?
1 second.
Can I add something?
No, sir, these hearings are recorded and anything you say could be used against you, okay? I give the complaint, it's due weight. I understand they're just allegations at this time, all right?
Okay, well, I called the police.
Mr. Rodriguez, I'm going to stop you there. I just don't want you to say anything that could potentially harm your case. This is the defense attorney here in the room. If you would like, I can come back there and speak with you, and touch base with you and provide any information that you provide to me, but I don't think you should speak in regards to open court at this point in time, because there is a court reporter taking everything down, and I just don't want you to negatively impact your case right now.
I won't.
I'm strongly advising against that, and if you'd like to talk, I'm happy to come back there and speak with
We
you.
could take a break so you can talk with Attorney Wyndham if you'd like.
Okay,
You would like a break?
no,
Okay.
well, actually, yes, a break, please.
Okay.
I apologize. To the
South
just,
Black is that your road?
yes,
Okay.
thank you.
You're good.
I was
Let's take
aware-
a short recess here.
Okay.
Sorry, I was aware of the.
I should send this
Hey, can you hear me okay?
This is Dane County versus Simon Zalua Varela, 26FO903. Can I have appearances, please?
All right, 1 second. What was the last name again?
Zalua, XELHUA hyphen Varela, VARELA.
Got it. Okay. The county appears by Assistant District Attorney Thomas Valerio. The defendant, Simon Shalhua Varela, appears in person in custody without counsel.
Great. So, let's make sure we have a good mailing address for you, Mr. Zalua Varela. We have a spot on Moraine View Drive. Is that where you'd like to receive your mail?
Yeah.
Okay, so we'll keep that address in our system. The state has decided to charge your case as an ordinance violation instead of as a criminal violation. Specifically, you're charged with 1 count of county disorderly conduct. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, it looks like you have another hold which would prevent your release. Looks like there's a DOC hold, okay? Is there an offer to resolve?
It's court costs only.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can tell me you would like to resolve your case. You'd be fined $114.50. Payment of that amount could be arranged through the clerk of courts, and you'd have 60 days to pay. Would you like to resolve your case today?
Yes.
Okay, then I'll enter a no contest plea on your behalf. I'll adjudicate you guilty. I'll enter a fine in the amount of $114.50. And with that, we are adjourned. Thank you. All right, we're back on the record in the state of Wisconsin versus Gabriel Rodriguez, 26 CF 953. Attorney Wyndham.
We have nothing further to add at this.
Okay. think some cash here is appropriate, although I think $1,000 is a little bit too high. I'm going to order $250 cash. The conditions that you have no contact with the district attorney's office except through written communication, that you have no contact with the men's shelter on the 2000 block of Zaire Road, that you have no contact with Devlin L. or Officer Cody, except in Officer Cody's position as a police officer. I don't think I worded that right.
Except only in their official capacity as a law enforcement
Yes,
officer.
no contact with Officer Cody except in their official capacity as a law enforcement officer, and that you not use or possess any dangerous weapons. I'll enter not guilty pleas to counts 2 through 4. Will the time limits be kept for count 1?
Yes.
We'll keep the time limits in place then, and we are adjourned.
Commissioner, did you order the no contact with Devlin L?
Yes.
Okay, thank you.
This is the state of Wisconsin versus Martell Hall, 26 CF 1135. Can I have appearances, please?
State appears by Assistant District Attorney Thomas Valerio.
Martell Hall appears in person and in custody and with Attorney Devontae Wyndham for the State Public Defender's Office. Mr. Hall is eligible for Public Defender Services. We would acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to the misdemeanor charge. And this is the message. So it's not an issue. The best address to receive mail is 6116 South 52nd Drive. Okay, I'm sorry. 6216 South 52nd Drive.
Is that in Madison?
Nope, that is in Laveen, Laveen Village, Arizona, 85339.
All right, you're eligible for the public defender and you have the right to have an attorney represent you in a case like this. They're going to work on getting somebody appointed for you as soon as possible, okay? So, find probable cause in the complaint. What are the state's recommendations?
I have no objection to a signature bond. I would ask that the defendant have no contact with the co-defendant, Eric D. Williams, rather, and that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription.
We'd have no objection.
All right, I'll order a signature bond with the conditions that you have no contact with Eric Williams, that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. I'll enter a not guilty plea to count 5. Will the time limits for count 4 be kept or waived? That's the possession with intent.
We would keep those time limits at this time.
We'll keep the time limits in place then, and we are adjourned. Thank you.
Next is Murray Allen. Murray Allen. Okay, we're some. You stay on the road.
This is the state of Wisconsin versus Murray Allen, 26 CF 1126. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Murray Allen appears in person, in custody, and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Allen is eligible for Public Defender Services. Your Honor, we'd acknowledge receipt of the complaint. We'll waive its formal reading. I believe the best address for Mr. Allen at this time is the Beacon. And We'll waive the formal reading of the complaint.
Right. You have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're gonna work on getting somebody appointed for you as soon as possible. I find probable cause in the complaint. What are the state's recommendations?
Recommending a $1,000 cash bail in this case. For conditions, I'm asking that the defendant have no contact with Johnny W. Their first name is spelled Johnnny. And that the defendant be banned from Reynolds Park. Okay. My understanding is that Mr. Allen had a previous bench warrant issued against him on December 17th, 2024. This is an Act 3 eligible offense. He's been previously convicted of multiple Act 3 eligible offenses in the past. Was convicted of misdemeanor battery in September of last year in Kenosha County. Was convicted of physical abuse of a child, recklessly causing harm in November of 2017 here in Dane County. That's from 17 CF 793. There was another misdemeanor battery conviction in 2013 in Juneau County under 12 CF 202. And then there was a strangulation conviction in 2010 under Dane County case 09 CF 1978. Here, I'll also note that this is Mr. Allen's fourth pending felony matter. So I think that cash is necessary at this point.
Attorney Wyndham?
Your Honor, we'd be seeking a signature bond here. I would note that Mr. Allen is eligible for public defender services. He did provide an address for the beacon here. I do believe that that shows his indigency in regards to the circumstances. He does have some ties to the community. He currently resides here in Wisconsin. He's resided here for the last 2 years. In addition to that, I would note that though he does have open cases here in Dane County, he is currently represented by an individual from my office. And we'd have no objection to the non-monetary conditions here.
All right. Well, I'm looking through the past cases. I don't see it in 26 CF 13, but I see in 26 CF 776 and 26 CF 937, there's conditions that you're not to consume or possess any alcohol. And in this case, your BAC is alleged to have been 0.230. The charges are Act 3 eligible. They again involve violence against somebody. This is your fourth open case. Cash here is just absolutely appropriate. I'm gonna order $1,000 cash with the conditions that you have no contact with Johnny W, that you're banned from Reynolds Park. These are all felony charges. Will the time limits be kept?
We'd ask for a timely prelim.
Okay, we'll keep the time limits in place then, and we are adjourned. Thank you.
Next is Dimitri McDavid. Dimitri McDavid. Stay on the LX.
This is the state of Wisconsin versus Dimitri McDavid, 26 CF 822 and 26 CF 1138. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Dimitri McDavid appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Your Honor, we'd acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to any misdemeanor charges. The best address for Mr. McDavid to receive mail at is 2070 Allen Boulevard, number 25, Middleton, Wisconsin, 53562. And Mr. McDavid is eligible for public defender services.
All right. You have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible. I find probable cause in the complaints. What are the state's recommendations?
In 26 CF 1138, I'm recommending a $500 cash bond with the condition that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription. And then in 26 CF 822, I'm also asking for a $500 cash bond with the condition that the defendant be banned from any Ulta beauty stores. So at the time of the January 27th, 2025 offense. Mr. McDavid was on bond in one felony case and one misdemeanor matter. And at the time of the February 21st and 24th and 26th incidents, he was on probation with the DOC warrant that was issued in September 2025. When back in March, when this case was initially charged, it's our understanding that Mr. McDavid was in absconder status, and he has a history of failing to appear, including on September 2024, November 2024, and May 21st, 2025. So I think some cash is appropriate amongst cases.
Attorney Wyndham?
And I would be seeking a signature bond here in these cases. Mr. McDavid is eligible for public defender services. He is a lifelong resident here in Dane County. Once again, I would note that though he's on a PO hold in relation to the circumstances, here, I do believe that, given the nature of these charges, drug-related, possessory drug offenses, as well as misdemeanor retail thefts, and some bail jumpings in regards to the circumstances here, I do believe that there's a pretty clear treatment need, and any amount of cash would essentially be holding Mr. McDavid, and essentially hold him to the point where he would not be eligible for any programming through DOC. I do believe that DOC is closer to the situation, and if they deem it appropriate to allow Mr. McDavid out for either intensive outpatient or any other kind of drug treatment, I would not like to bar them from doing that. So I do believe that a signature bond would adequately ensure his appearance in court and adequately protect the public, specifically in regards to the fact that there is DOC oversight in regards to the circumstances, and they are closer to the situation and can place Mr. McDavid in programming if they deem that appropriate. Thank you.
All right, any response from the state?
No.
One thing I see is people stacking up charges. They get charge after charge after charge. That leads me to believe that they kind of think their life isn't worth something. If there's people who feel like that in this courtroom today, I would disagree with them. Your life is worth something. These are drug offenses, property offenses, but they could lead to serious jail time and really a deep spiral that I don't want to see you fall into. So I hope something changes, because picking up charges like this is no way to live. All right. I want to see you value your life and spend your life outside of jail, not like this, not in that uniform. Okay. I'm going to order a signature bond, but you've got to pull your weight with that. Okay. You've got to show up for court. You've got to comply with conditions that I'm going to set, things like that. All right. That's going to be this court's expectation. If you don't follow through with that, things just stack, and they stack and they get out of control. You can already see that with some of these bail jumping charges. Okay. So just do what you got to do with court, take care of business, be where you're supposed to be, things like that. All right. There's a DOC hold, I believe. Maybe not. Strike that. So in 26 CF 1138, I'm going to order a signature bond. The conditions that you not consume or possess any controlled substances or drug paraphernalia without a valid prescription. If you think it could be helpful, and you can have a quick conversation with your attorney about this, I could order pretrial services to conduct drug monitoring. There's no wait list for that service. If you think that's helpful, if you think that extra oversight is needed, I could order that. I won't order it unless you let me know that would be helpful though.
No, I don't think that's necessary. I do believe that, given the DOC oversight, I think it would be a duplication of resources.
All right. In 26 CF 822, I'm going to order a signature bond with the ban from Ulta Beauty Stores condition. Now's your golden opportunity. You know, the best time to plant a tree is 20 years ago. Second best time is today. So let's take advantage of the opportunity today presents us. Do the best you can. In regards to time limits for any preliminary hearings, will those be kept or waived?
Your Honor, we'd ask for a timely prelim just to get the process moving.
Keep the time limits in place. I'll enter not guilty pleas to any misdemeanors, and we are adjourned. Thank you.
All right, this way. Next is Kevin Nemeke.
This is the state of Wisconsin versus Kevin Nemeke, 26 CF 1139. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Kevin Nemeke appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. At this time, we're unaware if Mr. Nemeke is eligible for public defender services. I'm handing him a copy of the public defender sheet. We would acknowledge receipt of the complaint. I do believe that count 2 may lack probable cause in the 4 corners of this complaint.
All right. So you have the right to have an attorney represent you in a case like this. You're eligible, or you may be eligible for the public defender. You'll have to apply. So you've got that information. I'd encourage you to apply as soon as possible. And looking and reviewing the complaint before the hearing today, I had a question about probable cause on count 2, the possession of a firearm on grounds of a school as a repeater. So we can start with the state.
Judge, I ask that you deny the motion. Within the 4 corners of the complaint, I do think there is a probable cause sufficient to support that count. As it's alleged therein, on April 27, 2026, employees of the high school involved in the criminal complaint indicated that they received information regarding a Snapchat post in which a student later identified as Mr. Nemeke was observed in possession of what appeared to be a firearm. GA notified Officer Dunnington that upon receiving this information, the school district staff formulated a plan to contact Mr. Nemeke upon his return to the high school to search him for firearms. With that purpose, and upon making contact with Mr. Nemeke, Mr. Nemeke enters into the school, was in the breezeway just outside of the Welcome Center. CH made contact with the defendant and told the defendant that they would have to have a quote conversation end quote with him before entering the building, and told the defendant that they would have to meet with another employee, at which point the defendant stated, quote, "I'm never doing that, I'm never doing that," end quote. He then immediately turned around, walked out of the breezeway, and was last seen walking eastbound on Flom Road. Later on in the criminal complaint, I believe there's reference to GPS tracking, where just trying to find him, where law enforcement observed his movements through that GPS monitor, and I believe they made it home. Mr. Nemeke made it home for a brief while before leaving. Toward the bottom of the complaint, at the top of page, I believe it's 4, LN, who is the defendant's mother, indicated that she took the defendant to school on Flom Road at around 9:30 a.m. The defendant then returned home unexpectedly at around 10:30 a.m. The defendant mentioned to LN, mom, that he came home because he needed a haircut. And then it was around this time that LN received a call from MMSD staff who alerted her to the defendant's flight from the school after they attempted to search him for firearms. And so the high school also told LN that they received a video of the defendant appearing him to be armed with a firearm outside of school property. So LN herself confronted Mr. Nemeke regarding the belief of the school staff that the defendant brought a gun to school. And instead of denying the existence of a gun being at the school grounds, Mr. Nemeke stated, quote, "They're after me, mom," and stated that the high school is not a safe place for him as he has to constantly look over his shoulder while he is there. The defendant was referring to rivals or opposition, not school staff. And it was at that point that LN located a firearm in the defendant's bedroom closet. LN picked up the firearm and placed it in a black plastic bag. What's also alleged in the criminal complaint toward the middle of page 3 is the fact that according to Detective Buccellato, who is a lead detective assigned to the underlying case for which Mr. Nemeke was on probation for, he was the identified suspect in an attempted first-degree intentional homicide investigation involved for his role in a shooting. He, as it's mentioned in the felon language, was convicted with first-degree recklessly endangering safety in connection with that incident. And so, as this court knows, as a convicted felon, he's not allowed to use or possess any firearms. But here, he also has a bag on his person, which is big enough to contain a firearm. He's running away from school staff who are trying to search him to see if firearms are on his person. And then he makes it home. A firearm is found in his bedroom that same morning after he surreptitiously flees from MMSD school staff. And his mom confronts him about it, and they find a gun in his possession. And instead of denying the fact that, instead of denying having the gun on his person while at the school grounds, he insinuates he has that gun. And I think it's a fair inference when you read it from the facts alleged in the criminal complaint, that he has that gun, bring it onto school grounds to protect him from the rivals and opposition that he's referencing in the middle of page 4. The probable cause standard is a flexible standard. It's a low one. And here, the inferences that can be made that are toward an innocent explanation are there, and that certainly exists. But there is also a culpable explanation showing that he tended to have a firearm, probably had a firearm on his person when he entered school grounds on the date and time in question. There's no other reason discernible throughout the criminal complaint why he would run from MMSD school staff when they were approaching him to search him for firearms. And he was on supervision. He knows he shouldn't have had a firearm. So I think that's a reasonable inference to draw. Explanations to the contrary are ripe for trial and are ripe for when the evidence needs to be more borne out through that trial. But I think that the probable cause standard has been met through the facts in this complaint.
All right, Attorney Wyndham.
Yes, Your Honor, I'd note that the possession of the firearm on grounds of a school is not the same as possession of individual possession of a firearm. Specifically, the state needs to establish that that at the time, Mr. Nemeke had the firearm at or on school grounds. In regards to the circumstances here, we have anonymous tip in regards to the circumstances on April 27th, 3 days prior to the alleged searching of Mr. Nemeke on school grounds. So the Snapchat in question and the video that the video that was alleged to have been viewed in relation to Mr. Nemeke possessing a firearm was not even on the same date in question in regards to the alleged time frame of Mr. Nemeke being on school grounds. Mr. Nemeke then is confronted, leaves school. There's no allegations that anyone saw said firearm in Mr. Nemeke's bag. There's no allegations that Mr. Nemeke admits that there was a firearm in his bag. This firearm is then located hours later in a closet. This is not a close enough nexus in regards to that of whether or not Mr. Nemeke possessed a firearm at the time when he was on school grounds. And that is what the state needs to show in order to establish probable cause within the four corners of this complaint. There's simply nothing in this complaint that establishes a nexus that while on school grounds, Mr. Nemeke had said firearm on his person.
Response from the state.
I would love to have every single case have direct evidence of guilt. This court knows that circumstantial evidence is no better or worse than direct evidence. And when we're talking about the probable cause standard, we're not talking about something as exacting as proof beyond a reasonable doubt, clear and convincing beyond a reasonable doubt. I appreciate defense counsel's arguments. I think they're certainly ripe for trial, but they're not relevant here. Here, it's clear from the circumstantial evidence in this case, Mr. Nemeke's actions on school grounds when being confronted with school staff who had the mental purpose of searching him for firearms, and he flees. Well, he walks away from the situation and says the quote that I mentioned, clearly indicating that he's not willing for that to happen. He's GPS tracked to his home. His mother confronts him a short time later. There's a gun in his possession, and instead of and I believe the actual language in the complaint is Ellen continued to confront the defendant regarding the belief of MMSD staff the defendant was bringing a gun to school. And in response to that, Mr. Nemeke, instead of saying, I didn't bring a gun to school, stated, they're after me, Mom, and stated that the high school is not a safe place for him. And again, I think that's a fair enough inference to draw that he's bringing a firearm to school to protect himself from rivals and opposition. It's not the only inference that we can draw, but it's an inference. It's a culpable inference. And as a result, any competing inferences are irrelevant. Again, I appreciate defense counsel's arguments. I think they're appropriate for trial. They're not appropriate here.
And Your Honor, if I may.
Yep.
I think we would have a completely different situation if the Snapchat or the video that the school district saw was from that morning. I think we'd be having a completely different discussion if the firearm that is alleged to have been located was located in the backpack. But we simply do not have either of those being the case in regards to the circumstances here. And I simply do not believe the state has established probable cause for count 2.
Yeah, there's a lot missing here that if it were there, it would make it really easy to find probable cause. So when Mr. Nemeke is searched, I heard the state say with the state that the school had the mental purpose of looking for a gun, but I don't think that Mr. Nemeke knew they were looking for a gun, which leads me to believe that he could have been walking away for any number of reasons. I don't know that it's reasonable to assume that he walked away because he knew they were looking for a gun. There's no, I don't see that inference there. It could be a guilty mind, but I just don't see that inference. There's a bag which could have held a gun, but there's no description about it appeared as if there was something in it, or if the bag was heavy, or the way the bag moved, that there was something as heavy as a gun in it. The Snapchat video, I thought I just want to double check the complaint. I believe Attorney Valero, you said that the Snapchat video was shot on the school grounds.
No, if I said that, then that was, I meant to say that it was not shot on school grounds. That's consistent with the complaint.
Okay, very good. So there's a Snapchat video of Mr. Nemeke allegedly with the gun, but that's not shot on the school grounds. Mr. Nemeke is searched. I think it's about an hour after this happens. And again, the gun isn't found in the backpack. It's found in a closet somewhere. Maybe it's a reason. Maybe it's an inference that he kept it and tried to hide it in his closet, but it doesn't seem to be reasonable. You know, I just don't see. There's just too many gray areas here that could be fleshed out and simply aren't. And I can't guess if there's nothing there pointing me to Mr. Nemeke actually having a gun at the school. So I'm going to dismiss count 2. I'll find probable cause for counts 1 through 3. What are these state's recommendations?
Recommending a $10,000 cash bond in this case. For conditions, I'm asking that the defendant not use or possess any dangerous weapons, as that's defined by the Wisconsin statutes, that the defendant be banned from Lafayette High School. And is there still a wait list for GPS monitoring?
Yes.
So I would ask that Mr. Nemeke be placed on the wait list for GPS monitoring at this point. A lot of my argument is basically taken from my arguments just a few moments ago. What I just highlight is the fact that, as I previously mentioned, Mr. Nemeke was previously convicted of first degree, I believe it was first degree recklessly endangering safety in February of 2026. And in connection with that case, he was placed on 6 years of probation. Furthermore, I'm not aware of any other adult criminal history, but that case involves a shooting incident where Mr. Nemeke was convicted of recklessly endangering somebody using a firearm, and he was on probation for it. And as a result, he's not allowed to have firearms. And here, just in April, just a few months after that conviction, he is conducting the alleged conduct in the facts throughout the criminal complaint. And he's in possession of a firearm in his room. He's on Snapchat, brandishing a firearm. There is certainly enough here to show that Mr. Nemeke is a bond risk. He had specific conditions not to use or possess a firearm by way of his, most likely his probation conditions, but also by the fact that he is a felon. It's illegal for him to possess a gun. And given the nature of the underlying offense, I think that there is a great amount of exposure involved in this case. He's facing substantial prison time, not only in this case, but in any revocation proceeding if the department chooses to seek revocation. So given all that, I think that substantial cash is necessary.
Attorney Wyndham?
Your Honor, we'd be seeking a more modest amount of cash. I would note a few things. First, Mr. Nemeke is 17 years old. He is currently a high school student. I do believe that the substantial amount of cash is absolutely unattainable for Mr. Nemeke, and I do believe that a more modest amount of cash would be appropriate here in regards to the circumstances. I would note that Mr. Nemeke is currently on a probation hold, so this is a little more academic in regards to the circumstances. And given the nature of this charge, I don't think an ATR is highly likely. But what I will say is that Mr. Nemeke is a resident here in Madison. He does have family that resides within the community. He does reside with his mom. In regards to the circumstances here, I do believe that a more modest amount of cash would adequately ensure his appearance here in court. And though these are possession of a firearm and possession of a dangerous weapon by an individual under the age of 18, these are not Act 3 eligible matters. And I do believe that the purpose of cash bail is to adequately ensure his appearance in court. We did hear that Mr. Nemeke was facing serious charges in regards to the previous circumstances, but what we didn't hear is any prior missed court appearances. And so I do believe that a more modest amount of cash would adequately ensure his appearance in court. I think in the amount of $2,000 to $3,000 would be appropriate.
Great. Any response to the state?
Well, what I would just reiterate is that it's not every single day you see someone who is convicted of a shooting related offense, is on probation for that shooting related offense, and then promptly right after being convicted of that shooting related offense, allegedly obtains and possesses a firearm. And not only doing that, just displays it on Snapchat. He's on a serious level of probation. It's for a serious offense. He shouldn't be having firearms. And he's doing exactly that just months after the conviction. So I think he is a bond risk. I think cash is appropriate.
I agree with the state. $10,000 is more than appropriate. A lot of people might even say that that's a little bit low. I'm going to order that you not use or possess any dangerous weapons, and that you're banned from La Follette High School. I'm going to order pretrial services for GPS monitoring. Well, I'm going to order pretrial services for GPS monitoring. But if you're already being supervised, unless you're already being supervised by a GPS monitoring system. So if you're released and you're on DOC GPS, you won't have to comply with GPS through pretrial services. But if you're not on GPS through DOC, then you will have to report to pretrial services to get connected with an electronic monitoring device, okay? I'll enter a not guilty plea to count 3. Count 1 is a felony. Will the time limits be kept?
Yes.
We'll keep the time limits in place then, and we are adjourned. Thank you.
Next is Vintage Gemma. Vintage Gemma.
Or Amanda, yeah.
You stand over the place.
This is the state of Wisconsin versus Vintage JAMA 26 CM 1155. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Ms. Jamo appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Ms. Jamo is eligible for public defender services. We'd acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to the charges. And the address on the complaint appears to be correct.
All right. You have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're gonna work to get somebody appointed to your case as soon as possible, okay? I find probable cause in the complaint. What are the state's recommendations?
I have no objection to a signature bond. I would ask that the defendant have no contact with the child victim. Their initials for the bond form are KC.
Your Honor, we'd have no objection to the signature bond. I guess the only circumstances, obviously, these two individuals go to the same school. I'm not sure what the circumstances surrounding the ability to separate them in regards to their classes and class schedule will be. I understand that the state is not asking for a ban from the high school at this point in time. It's my understanding that Ms. Binta will be, I'm sorry, Ms. Jamel will be graduating here in June. And so shouldn't be an issue at hand for very long, but I just want to ensure that she's able to finish school.
Well, the victim in the complaint says she was bullied for a while before this allegedly happened. She was allegedly beaten pretty badly.
And
I think I'm sorry.
And I just want to kind of address the issue. We did reach out to MMSD just to inform them of the possibility of the no contact. They said they'd be able to accommodate the I guess separating them for the purposes of the bond condition.
I'm going to order the no contact condition in the signature bond. So Ms. Jama, it's going to be your responsibility not to have any contact with KC. You see him coming down the hall, you need to go somewhere else. Avoid them, okay? Don't have contact with them through a third party, so you can't have somebody else contact them on your behalf. You can't contact them through social media, email, anything, okay? I'll enter not guilty pleas on your behalf. I believe that's all I can do for the parties today, so we are adjourned.
Next is Devin Bizzell Price, appearing to be the Zoom.
Yeah. Spell this wrong.
And do we have Mr. Bizzell Price? Can you give me a thumbs up? All right, this is the state of Wisconsin versus Devin Bizzell Price, 26 CM 1161. Can I have appearances, please?
He state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Mr. Bizzell, please, can you hear us okay?
Yes, sir, I can't hear you.
Okay. Your Honor, Mr. Bizzell Price appears via Zoom from the Dane County Jail with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Bizzell Price is eligible for public defender services. The best address for him to receive mail is 2206 University Avenue, apartment 312. Is that address correct? I got a thumbs up. Your Honor, we'd acknowledge receipt of the complaint. We'll waive its formal reading and stand mute to the charge.
Right. So Mr. Bizzell Price, you're eligible for the public defender. You have the right to have an attorney represent you at hearings like this. They're going to work on getting somebody appointed to your case as soon as possible, okay? I find probable cause in the complaint. What are the state's recommendations?
I'm recommending a $500 cash bail in this case with the condition that the defendant have no contact with Taliana M.B. Their first name is spelled Taliana. I would also ask that the defendant be banned from the 900 block of Janesville Street in Oregon, Wisconsin. My understanding is that Mr. Bizzell Price was previously ordered to have no contact with Taliana M.B. And then he was released the previous day from this case, from May 19th, with bail conditions not to have contact, and he, to our understanding, immediately violates his condition. Mr. Bazell Price has some bench warrants issued against him in the past, one on January 2024, another on May 1st, 2023, that he was in warrant status for until December of 2023. Another one in December 2022 and August of 2022. So I think some cash is needed.
All right. Attorney Wyndham?
And I'd be seeking a signature bond here. I would note that Mr. Bazell Price is eligible for public defender services. I would also note that Mr. Bazell Price is currently on a fixed income. He does receive Social Security income. And when looking at the facts of this case, I do believe that the non-monetary conditions are appropriate. But when looking at the facts of the case in regards to the nature of the offense, I do believe that this was more of a mental health related circumstance. And I do believe that a signature bond is still warranted given the nature of this charge. I would note that in 26 CM 1120, Mr. Bazell Price is currently waiting for an attorney in relation to the circumstances. There was no missed court appearances in regards to that. But I would note that it does appear that Mr. Bazell Price has a good address to where he can reside at. He is a lifelong resident here of Wisconsin, and he does have parents and friends and children that reside within the community. For all those reasons, I don't believe that Mr. Bazell Price is a flight risk, and I do believe that giving him another opportunity, coupled with the nature of the mental health circumstances here, a signature bond is still appropriate.
All right, any response?
No, thank you.
Okay. Here, Mr. Bazell Price wasn't able to miss any court because he was released on a signature bond May 18th. This is alleged to have occurred May 19th. That gives me little confidence that if I release him on a signature bond again, he would comply with the conditions. In fact, it might reinforce that there are very little consequences for violating my order. Here, I think $250 cash is appropriate. Mr. Bazell Price, I'm going to order that you have no contact with Taliana B, and that you're banned from the 900 block of Janesville Street in Oregon, Wisconsin. I'll enter a not guilty plea on your behalf, and we are adjourned. Thank you.
Next is Brittany Johnson. Brittany Johnson. Big word. There we go.
This is the state of Wisconsin versus Brittany Johnson, 26 CF 1137. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Brittany Johnson appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Ms. Johnson is eligible for public defender services. The address on the complaint appears to be correct. We'd acknowledge receipt of the complaint. We'll waive its formal reading.
And did you say Ms. Johnson was eligible for public defender?
I did.
So you have the right to have an attorney represent you in a hearing like this. You're eligible for the public defender, and they're going to work on getting somebody appointed for you as soon as possible. I find probable cause in the complaint. What are the state's recommendations?
I have no objection to a signature bond. I would ask that the defendant have no contact with Matthew G, that the defendant be banned from the 800 block of Stephen View in Waunakee.
I'm sorry, what was that last condition?
Banned from the 800 block of Stephen View in Waunakee.
Attorney Wyndham, when you're ready.
Your Honor, we'd have no objection at this time in regards to the no contacts as well as signature bond. I do note that currently Ms. Johnson does not have stable residence in regards to good mailing address, but she will be signing up for text message alerts to ensure that she does not miss any court appearances.
Okay. I'm going to order a signature bond with the conditions that you have no contact with Matthew G., that you're banned from the 800 block of Stephen View in Wanakee. When you get a good mailing address, you should update that. Would you like us to change it to like the job center or the Beacon, a family member, something like that?
I can do the last one, so I don't have the address now,
Okay,
but I can update it as soon as possible.
okay. I'd encourage you to do that.
Yeah.
Given that I believe this is the victim's address, is there a placeholder we can put in place so that mail is being sent to the victim's address, or does it? Should we just keep what's in
Move
there?
the address entirely. Otherwise, I assume the defendant could set up some sort of mail forwarding with the post office.
All right. Attorney Valerio, do you have a position on that?
Are you, I apologize, were you trying to see where a good alternative mailing address would be for Miss Johnson?
No, whether. So we have her mailing address as the victim's address, which means if we keep it in there, the victim's going to get mail on her behalf.
Right.
Should we just remove the address
Uh,
as a victim? I noticed in the complaint, the victim says they don't wish to press charges, but does want an injunction.
When we reached out to the victim yesterday, they indicated they wanted no contact, banned from the home. So yeah, I would say let's remove the address entirely.
Any position, Attorney Wyndham?
No, I think that's perfectly fine and we'll waive time limits.
Okay, we'll waive those time limits then. We'll get that address removed from our system. You should sign up for the text message notification, okay, so you don't miss court. And with that, we're adjourned. Thank you.
Next is Amy Tomlinson.
This is the state of Wisconsin versus Amy Tollefson, 26 CF 1141. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Ms. Tollefson appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Ms. Tollefson is eligible for public defender services. We would acknowledge receipt of the complaints. We'll waive its formal reading. The best address for Ms. Tollefson is it 5?
It's fine. 5, Risley. Yeah, but I'm not on 3. Oh, well, then you're good.
Very good. The address on the complaint appears to be correct.
Sorry, did you say she's eligible for public defender?
I did, and she is.
So you have the right to have an attorney represent you in a case like this, ma'am. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible. I find probable cause in the complaint. What are the state's recommendations?
I have no objection to a signature bond. I would ask that the defendant not use or possess any pieces of mail or parcels that aren't addressed to her. I would ask that the defendant be banned from the package room at 958 Rise Avenue. And that the defendant be banned from the property manager's office at 958 Rise Lane. I would also ask that the defendant exhibit no acts or threats of violence towards Diana D.
That was Diana D.
Yes,
You said no acts or threats, or was it a no contact?
it was a no acts or threats.
You said no extra threats?
Right.
Okay, cool. I was just like, she's the property manager, right?
Right.
We'd have no objection.
I'll order a signature bond with the condition that you not possess any mail or packages not in your own name. That you're banned from the package room and the property manager's office. Was there an address associated with those?
The first one I heard was 958 Rise Avenue. It's not
Be lane.
It's a different address.
It says Risley. It's not Avenue.
Yeah, I agree. It should be Rise Lane instead of Avenue. Sorry.
So,
Same address for both, right?
Correct.
and that you make no acts or threats of violence to Diana D. This is a felony. Will the time limits for the prelims be kept or waived?
We'll wait time on that.
Okay, time limits will be waived then, and we're adjourned. Thank you.
Next is Angela Evans.
This is the state of Wisconsin versus Angela Evans, 26 CF 1134. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Angela Evans appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. So Evans is eligible for public defender services. Will acknowledge receipt of the complaint. The address appears to be correct. However, we would ask to add a care of Deborah, Deborah Evans. And we'll acknowledge receipt of the complaint and waive its formal reading.
You have the right to have an attorney represent you in cases like this. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible. I find probable cause in the complaint. What are the state's recommendations?
I have no objection to a signature bond. I would ask that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription.
We'd have no objection.
I'll order a signature bond with the conditions that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. These are felonies, which means you're entitled to have a preliminary hearing within a certain amount of time.
We'll waive time limits.
Okay, time limits will be waived and we're adjourned. Thank you.
Yeah. Next is Tasha Olson appearing via Zoom.
This is a forfeiture.
What is my law?
We have Ms. Olson. And do we have Ms. Olson? Can you give me a thumbs up? You'll need to be unmuted. There we go. This is Dane County versus Tasha Olson, 26 FO 896. Can I have appearances, please?
The county appears by Assistant District Attorney Thomas Valerio. The defendant, Tasha M. Olson, appears via Zoom in custody without counsel.
So Ms. Olson, we have a mailing address for you on County Road I. Is that still a good spot for you to get your mail?
#801 North Pine Street, Sun Prairie.
Is there an apartment number?
801 is the building number, it's a duplex.
Okay. So the state has decided to charge your case as an ordinance violation instead of as a criminal violation. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases that could affect your release, and is there an offer to resolve?
It's court costs only.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can tell me you want to resolve the case. I'd enter no contest plea and adjudicate you guilty. You'd be fined $114.50. You have 60 days to pay that amount, and payment could be arranged through the clerk of courts. Would you like to resolve your case today, ma'am?
Yes,
Okay, then I'll enter a no contest plea for you, adjudicate you guilty, enter a fine in the amount of $114.50, and we are adjourned. Thank you.
released today, right?
Yep, assuming you
thank
have
you.
nothing else affecting your release.
Next is Deshaun Rutledge. Sean Road.
This is the state of Wisconsin versus Deshaun Rutley, 25 CM 1715. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
We're also here for 26 CM 1162.
John Rutley appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. One second, I got it. Ms. Rutley is eligible for public defender services. Your Honor, we'd acknowledge receipt of the complaint. The best address for Mr. Rutley at this time is 615 East Washington Avenue. We'll acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to the charges.
So you have the right to have an attorney represent you in a case like this, Mr. Rutley. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible, okay? I find probable cause in the complaint. What are these state's recommendations?
Well, in 25 CM 1715, I'm asking for a $500 cash bond. Well, I'm asking that the signature bond be converted to a $500 cash bond, keeping the same non-monetary conditions. And then in 26 CM 1162, I'm requesting a $250 cash bond with a condition that the defendant be banned from the UW campus area, according to the ban map. Right. So as this court knows, back in, I think it was September of last year, Mr. Rutley failed to appear for just trying to quickly make sure I'm getting it right here, for a pretrial conference after he was given a signature bond. And he remained in warrant status for months. He wasn't picked up until I think yesterday, where Mr. Rutley is alleged to have been observed by law enforcement. He gives a false name to law enforcement, and when law enforcement discovers his true identity, they find out that he has an active warrant for his arrest. So look, I think that's a substantial enough reason to ask for cash bail. I think Mr. Rutley's doing his, I think Mr. Rutley is evading capture throughout the cases, and that shows he's a bond risk.
Attorney Wyndham?
1 second.
It's $500 and 26 CM 1160. Was that correct?
I was proposing that it be in the 25 CM case and asking for $250 in the 26 CM case.
Attorney Wyndham?
Your Honor, I would note that Mr. Rutley was in custody in Mr. Rutley, you gotta let me speak. It's all good. Mr. Rutley was in custody in Indiana in relation to that missed court appearance here in September. He was not extradited given the nature of the misdemeanor nature of the charges. It's my understanding that he was not released until March of this year in relation to the circumstances. Mr. Rutley then returned back here to Madison, and I guess was arrested here less than 2 months later in regards to that missed court appearance. As far as the circumstances surrounding the nature of these charges, I would note that we have a disorderly conduct, a misdemeanor bail jumping, and an obstructing an officer charge here. The risk for flight is not significant given the circumstances surrounding the circumstances here. I'm just trying to see if there's any notes. And so as far as the circumstances here, I do believe that the likelihood for significant incarceration is low. Given that and given his public defender eligibility, Mr. Rutley has provided an address of the Beacon, as well as, informed my office that he is currently homeless and relying on shelter services. I do believe that any amount of cash would essentially be holding him indefinitely. And so for those reasons, I do believe that a signature bond would be appropriate here, given the lack of likelihood for significant incarceration. Thank you.
All right, any response from the state?
Well, if he's getting arrested or confined in the state of Indiana, it also shows to me he has some lack of ties to the community. And, you know, even when he's out of custody, he's still giving a false name to law enforcement. So I think that all clearly shows that cash is appropriate.
This is a tough case. Also makes it tough is looking at the complaint. Looking at page 2, or I'm sorry, page 2 of 3, it's a paragraph. 1, 2, 3 above the bail jumping subheading. It says Officer Kaufman reports the defendant finally revealed his true identity to Officer Cunningham. Officer Kaufman inquired as to if the defendant had warrants for his arrest, and he stated he did. That leads me to believe that Mr. Rutley was aware of the warrants and had failed to turn himself in. You know, maybe he couldn't make court because he was incarcerated in another state. I think that cuts both ways. Here, the contact was due to Mr. Rutley sleeping on a bench. By order of signature bond, are you going to show up for court?
Yes, I am.
Okay. It's going to be your job to do that, okay? Because if you fail to make court again, it's likely that cash is going to be imposed, all right? And your attorney, yep, and your attorney is telling me that any amount of cash might lead to your incarceration. So please make sure you're showing up for court. I'm going to order in 25 CM 1715 a signature bond. The conditions will remain the same, that you have no contact with Jason K, that you not be in the State Street Langdon area per the band map, and we'll get you a copy of that map. And in 26 CM 1162, I'm going to order a signature bond with the conditions that you not be on the UW campus as outlined by the band map. I believe that was a state's request, right? Okay. I'll enter not guilty pleas on your behalf, and we are adjourned. Thank you. You should ask your attorney.
This is where they're saying in the new case, this is where they're saying that you were arrested. And so they're being honest. Yeah, and so they're planning you for both these areas. And I hear you. All right. Look.
Next is
Oh,
Eric
no,
Williams.
they gave you a signature bond. They're gonna release you.
Eric Williams. He's down in the yellow bags.
This is the state of Wisconsin versus Eric Williams, 26 CF 1136. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Eric Williams appears in person and in custody and with Attorney Devontae Wyndham for the State Public Defender's Office. Mr. Williams is eligible for Public Defender Services. The best address for Mr. Williams to receive mail would be 815 Cedar, Cedar Street, apartment number 344.
Yes,
Is that Madison, Wisconsin?
yes.
Madison, Wisconsin, is that, he knows it,
I think hopefully.
53704. Your Honor, we acknowledge receipt of the complaint. We'll waive its formal reading. And Mr. Williams is eligible for Public Defender Services.
So you have the right to have an attorney represent you in cases like this. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible. I find probable cause in the complaint. What are the state's recommendations?
I'm recommending a $5,000 cash bond in this case. Per conditions, I'm asking that the defendant have no contact with the co-defendant, Martell C. Hall. that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription. I'll note that it's my understanding that Mr. Williams has 30 years of criminal history outside of Cook County, with numerous prison sentences, including 3 prior drug trafficking convictions, rather. There were also grand total 5 prison cases outside of Cook County. 6 of them involved 6 felony convictions in total as well. It's also my understanding Mr. Williams is a sex offender and also has a history of possessing firearms illegally. I'm mentioning that not only to mention the amount of exposure that's involved in this case, but also to point out the relative lack of ties to Dane County here. Also note, for what it's worth, this appears to be a strong case. Mr. Williams sold to a confidential informant several times. When he's pulled over on a different day, the drug buy phone is found in his possession, and he vaguely admits that he sold drugs. So when I look at the totality of this case, I think that there's a high amount of exposure, lack of ties to the community. So I think that substantial cash is needed.
Right. And when you say outside of Cook County, what do you mean?
I probably meant to say out of Cook County.
Okay. I see.
Sorry.
That makes more sense. I think we're all on the same page now. Attorney Wyndham?
Yes, Your Honor, I'll be seeking a signature bond consistent with the public safety assessment. First, I would note that Mr. Williams is listed as a 2 out of 6 on the failure to appear score, a 3 out of 6 on the new criminal activity score. I would also note that this is not an Act 3 eligible offense. This is not considered violent in nature. In relation to the circumstances here, the purpose of cash bail would be to adequately ensure an individual's appearance for court. What we've heard is a number of felony convictions that Mr. Williams has out of state. What we have not heard is any prior failures to appear. Though there are prior convictions, as noted in regards to the on the PSA, there are no prior failures to appear in the last 2 years, as well as no prior failures to appear outside of 2 years. So with all that being said, though these charges are serious and felony in nature, I do believe that a signature bond would adequately ensure his appearance in court. Mr. Williams has shown the ability with serious offenses in the past to appear for court. And for those reasons, I do believe that a signature bond would adequately ensure that appearance. I would also note that Mr. Williams has provided an address here for Dane County, Madison, Wisconsin. And he's resided here for the last year after moving from Chicago.
Right. Does the state have a response?
Well, according to his booking information, he was reported to have an address at 6424 South Tallman Street. That's in Chicago, Illinois. And then furthermore, I think when I just, again, looked through his criminal history, he's, again, continually demonstrated that he has stronger ties to Cook County, Illinois, instead of Dane County. This, like I said, this is a strong case. That's a proper bail consideration. Lack of ties to the community, that's a proper bail consideration. So I think that equates to substantial cash, especially with the amount of exposure on the line.
Your Honor, if I may, the strength of the state's case is not a proper bail consideration in regards to that unless it's an Act 3 eligible offense. This is not. I do believe that the ties to the community is a proper bail consideration. And as stated, Mr. Williams has provided an address for residents here in Dane County and has indicated that he has resided here for the last year. Thank you.
All right. I do see one prior case from Dane County or from Wisconsin. When I conduct a statewide search with Mr. Williams' name and birth date, it was ultimately dismissed. It was a possession of THC case from alleged to have occurred in April of 2001. Here, I think the exposure with the other cases is high. There is a lack of ties to the community, even if he intends to reside here now. There's still a significant ties outside Wisconsin. That being said, I think $5,000 is a little bit too high. I'm gonna set bail in the amount of $750. I'm gonna order that you have no contact with Martell Hall and that you not consume or possess any controlled substances or drug paraphernalia without a valid prescription. These are felony charges. Will the time limits be kept?
Yes.
We'll keep the time limits in place then, and we're adjourned.
Next is Urban Rugano.
Okay. All right. Good luck. Thank you.
Rugano. That's fine. We can switch to Xavier Chrome. Xavier Chrome. Can you stand and go, Alex?
This is the state of Wisconsin versus Xavier Crone, 22 CM 1463. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Xavier Crone appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Crone is not eligible for public defender services. I have handed him a copy of the public defender sheet. Your Honor, we'd acknowledge receipt of the complaint. We'll waive its formal reading and stand mute to the charges.
All right, you have the right to have an attorney represent you in cases like this. You're not eligible for the public defender. One thing you can do is reach out to the clerk of court's office, let them know that you're not eligible for the public defender and ask for county representation. The county, if you meet their criteria, might cover some of the costs of your representation, okay? If I'm probable cause of the complaint, what are the state's recommendations?
You don't know if he provided his conviction DNA, do you?
That's a common question. I checked the jail computer before we started. He provided it yesterday.
I have no objection to a signature bond. I have no non-monetary conditions to recommend.
No objection.
Then I'll order a signature bond with the standard conditions of court. I'll highlight too that you'll follow the law and that you'll show up to court whenever court is scheduled. I will enter not guilty pleas on your behalf and we are adjourned. Thank you.
Can I ask how I'm gonna be notified?
By mail, we send notices through the mail. They'll also be your next court date on your signature bond form.
Okay, perfect, yeah, I just didn't know which address it's going to.
The address we have is the Livingston Street.
Livingston, could I change it to 2110 McKenna Boulevard?
Yep. That's Madison,
Yeah, west side, okay,
537.
it's 53703, okay, I'm not sure exactly.
That doesn't sound quite right. Is your apartment number?
303.
But it's 537 and 11.
Okay, thank you. Okay, this way, sir.
Thank you.
Thank you, guys.
I don't know. I've been getting mixed signals about what we're
This is the state of Wisconsin versus Berman Lugama, 26 CF 1140.
I'm just gonna ask you to,
Mr. Larson, have you been sworn in?
Yes, I have.
Okay, and you're aware you're still under oath?
Yes, I am.
Very good. Can I have appearances, please?
The state appears by Assistant District Attorney Thomas Valerio.
Berman Rugama is eligible for public defender services. He appears in person and in custody and with Attorney Devontae Winter from the State Public Defender's Office. We did acknowledge receipt of the complaint and we'll waive its formal reading. Though I would ask that the count and the penalty range be read.
All right. So you're charged with one count of operating a motor vehicle without owner's consent. That count alleges that on or about Wednesday, May 20th, 2026, in the town of Vienna in Dane County, Wisconsin, that you intentionally took and drove a vehicle, a Dodge pickup, without the consent of the owner, MRR. That's a Class H felony, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 6 years or both. You have the right to have an attorney.
And then I do have an address update for the court. 1639 Gaston, Gaston, Sauk City, Wisconsin, 53555.
That's low dive, but I'll take a look at that.
So you have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're going to work on getting somebody appointed for you as soon as possible. This case is separate from the tickets that I believe arose out of the same incident.
Can you repeat that, Your Honor? But
Yep.
this case is what?
Separate from the tickets that arose out of the same incident.
I tried to look up that address, I did not find that address, and saw the address on the plane. It might match out the end of 1639 Gas Grill Road.
It's a city,
in Lodi.
Gas Road, Lodi.
Do you know the last name?
Is this something called Yes. What? So it should be N 1639 Gas Road, Lodi, 53555.
Alright, so we'll keep the address.
I think it also considered this section.
Find probable cause in the complaint. What are the state's recommendations?
I have no objection to a signature bond. I would ask that the defendant not operate a motor vehicle without a valid driver's license, that he not use or possess any alcohol, and that he have no contact with Mason R.
Mason.
That was no alcohol or not operating a motor vehicle within the alcohol.
Straight no alcohol.
Bueno, que no consumo.
Attorney Wyndham,
We'd have no objection.
I'll order a signature bond with the conditions that you not operate a motor vehicle without a valid license, that you not consume or possess any alcohol, and that you have no contact with, I believe it was Mason R. This is a felony. Will the time limits be kept or waived?
O sea, si negociamos las fechas límites, debemos hacer. Pero digamos, sí podemos hacerlo las actividades pasadas mínimo también. Eso es tipo que signos
We can waive time limits.
Time limits will be waived and we're adjourned. Thank you.
Um,
26 CF 1140.
1140, okay.
Correct.
yeah, mine comes with like a blank case number.
Yeah, I was trying to look at yours. No information.
And, you know, sometimes the information on your data sheet is completely wrong, so I'm like, gave me an updated address and it's not the right address.
This is the state of Wisconsin versus Henry James Johnson, 26 CF 1119. Can I have appearances, please?
State by 88, David Olson.
Attorney Devontae Wyndham appearing on behalf of Henry Johnson. Mr. Johnson does not appear. He is currently in the Dane County Jail. However, it's my understanding that there are been some technical issues going on at this given moment. I would note that he has a right to appear in person. It does appear that he does have private counsel. Private counsel also has not appeared. The private counsel has reached out to my office. I don't have an update in regards to the terms or the circumstances surrounding that.
All right. And it's my understanding that some attempts were made, but there were technical difficulties, and for safety reasons, Mr. Johnson needed to appear by Zoom. Okay. What's the state's position?
I should also note, Commissioner, that Mr. Johnson is being held on some audio evidence too.
Okay.
And Your Honor, given the fact he's being held on other matters, I would just suggest we set this matter over for a time. Hopefully those technical issues can resolve themselves and we can set bond at that time.
Attorney Wyndham.
Your Honor, I would note that there are time limits in regards to when these initial appearances need to be held. I would note that the last day was for today. I understand that he's being held on other matters. However, I would ask that if this is going to be rescheduled, that we get this rescheduled as quickly as humanly possible. And so I know there's initial appearances scheduled for tomorrow, and if at all possible, I would say that we get this on the calendar for tomorrow.
I assume that's okay with the state attorney Olson.
That'd be fine.
Great. We'll try to get this on for tomorrow. I don't think there's any unfair prejudice to Mr. Johnson, as he's going to be held on the warrants anyways. Hopefully the technical issues will clear up by then. I believe that's all I can do for people, so we're adjourned. Thanks, everyone.
And that is everyone today.